All right. We will welcome to this ACAN track event on targeting oligarchs. ACAN is the Anti-Corruption Advocacy Network, which is an active group of 850 people. Jody Vittori co-convenes this. Leila Hashemi, who will be with us, also is part of it. Tom Firestone is part of our network. And in the last 11 days, we've been absolutely swamped with questions. And so I decided to ask Tom Firestone, who I've known for over 2 decades, to help answer the questions that we're getting from the media, from the interested public, on how do we target oligarchs. Let me give you a little bit on Tom Firestone's background and why he is the perfect person to be addressing these questions. So Tom has a terrific background in Russian affairs. He has an MA in political science from Berkeley, in which he focused on Russia. And then he already knew early in his life that he wanted to focus on organized crime, and he went to Harvard Law School and then became a federal prosecutor in the Eastern District of New York. And then I got to know Tom a bit during that time and later when he was posted as the DOJ representative in Moscow. And at that, he had responsibility of coordinating with our project that TraCCC then had of working in conjunction with Russians in centers across Russia on transnational organized crime and corruption. And TraCCC's current focus on environmental crime is in part due to Tom's encouragement that we pursue this direction. Tom has been in private practice since he left DOJ, but he has just this incomparable understanding of Russian society, just a superb language capacity in Russian, and years of experience working in this field, apart from being a superb lawyer. And he's also written a seminal piece that we've put in the chat box on corporate raiding, which occurred in 2008, and which we'll discuss today because it's very essential to understanding sources of vulnerability in Russia and the economic climate created and maintained by the oligarchs. So without further ado, I'll turn the floor over to Tom. I want you to introduce yourselves in the chat box because part of this event is to develop the community that we have here and sustain. This talk is going to be recorded and posted shortly. And we also invite you to ask questions. And Tom is going to talk only for about a half hour so we can really have a very lively exchange with this incredibly high-level audience that's responded to our rapidly convened presentation. So with that, I'll turn the floor over to Tom and thank the TraCCC staff. The TraCCC is the Terrorism Transnational Crime and Corruption Center at George Mason University that's been deeply involved in issues of kleptocracy, transnational crime, corruption for its whole existence. And so you can see more in the chat box, but we'll deal with the immediate issues of today. So thank you, Tom.
Thank you very much, Louise, for those kind words. And I got to repay the compliment. You mentioned I was in graduate school. I was in a PhD program at UC Berkeley way back when, in the late 80s, early 90s. And I remember I wanted already then to write on organized crime in the former Soviet Union. I asked my dissertation advisor, Gail Lapidus, whether or not anyone was working in this area, and said, not really, there's not much going on, but there is this one scholar named Louise Shelley who's been writing on this. And that was 20 some years ago, maybe I guess 30 years ago. So Louise was really ahead of the curve on this and has really defined the field and the academic study of this subject for so long. And ACAN is just a great is a great forum. I recently moved law firms. I was previously at Baker McKenzie, and I've now joined Stroock Stroock Lavan, as you see from the slides. And one of the first things I did after I moved firms, was I wrote to Louise and Jody, and I said, make sure you have my new email address for the ACAN listserv, because there's so much great discussion and information that goes around on that. So at any rate, thank you, Louise and Jody, for giving me the opportunity to talk to this great audience today, for assembling the audience and creating a forum for the discussion of this issue. So with that, let's get into the presentation. If we go to the first slide, please. I think we were all of us who follow these issues were struck by President Biden's comment during his State of the Union address last week, in which he said that it's going to be a priority for the U.S. government to go after the oligarchs. You see his exact words there: to the Russian oligarchs and the corrupt leaders who built billions of dollars off this violent regime, no more. We are joining with European allies to find and seize their yachts, their luxury apartments, their private jets. We're coming for your ill-begotten gains. I think he meant ill-gotten gains, but whatever, you know. we're coming for your dirty money, is what he meant to say. The U.S. Department of Justice is assembling a dedicated task force to go after the crimes of Russian oligarchs. This is followed up by Deputy Attorney General Lisa Monaco saying basically the same thing. She's going to be running the task force, supervising the task force at a high level. I understand the day-to-day operations are going to be run by a prosecutor in the Southern District of New York. But she said, we will use every tool to freeze and seize your criminal proceeds. This provoked a lot of discussion. As Louise said, she and I, and I'm sure a lot of you, have been getting a lot of calls from a lot of interested parties, media, activists, businesses, scholars. What does this mean? Can they actually seize the property of oligarchs? How can they do it? Can they just designate somebody for sanctions? And if you sanction somebody, is that enough of a basis to seize their property? If not, how do you do this? How is this possible legally? Can the oligarchs defend themselves? And when are we going to expect results from the task force? So these are some of the issues that I wanted to address today. And I thought it might be useful just to provide a legal context for what's going on now, because a lot of times this is lost in the drama of the reporting around it, what you actually have to do, what you can and can't do. And so that's really the goal of today's discussion. So as Louise said, I'll spend about a half an hour discussing all of that. And then I hope we'll throw it open to discussion, because I know there are a lot of great questions out there. Louise sent me some questions in advance, which really had me up last night thinking about how to answer them, because there aren't good answers to some of these questions. So I think we'll have a great discussion. So let's just, if we go to the next slide, please. One thing I just want to make clear at the outset is that sanctions and forfeiture are two different things legally, and I think they often get conflated in the public debate. Sanctions, what we hear, you know, Usmanov, Deripaska, all of these people being sanctioned by OFAC, put on the SDN list, is not the same as seizing their property. What happens is when somebody is designated by OFAC, their property is blocked. No U.S. person can have any transactions or dealing in that property. That does not mean that the property is seized. It's blocked, but not seized. When somebody is designated, the government does not need to prove a crime. They don't need to go to court for this, and they don't have to prove any connection between the property and the reasons for somebody being designated. So if an oligarch owns property in New York and he is being sanctioned for something to do with Crimea, say, the government doesn't need to show any connection between the property that is going to be blocked and the reasons for him being designated. Whatever property he has that's under the jurisdiction of the United States is going to be blocked immediately. That's the sanctions regime. Forfeiture, which I believe is what President Biden was talking about last week, is something very different. That does result in seizure of the property, not just blocking, but seizure of the property. That's not done by OFAC. That is done by the Department of Justice with, of course, the investigative partnership of the FBI. And I know we have Karen Greenaway on the line today, who's a great former FBI agent who worked on a lot of these cases, and I hope that Karen will jump in from time to time with her comments. But forfeiture is pursued by the DOJ on the basis of evidence collected, usually by the FBI. It does require a judicial order. It does require proof of a crime, and it requires proof of a connection between the property to be forfeited and the underlying crime. And those last 2 points there about proof of crime and proof of a connection between the crime and the property, I think are crucial when we talk about what the task force is going to be doing and what results we can and cannot expect from the task force in the near term. So let's just go to the next slide. Sanctions. I've gotten a lot of questions, including from very experienced lawyers, saying, how is it the president could just sanction somebody? Isn't there any due process around this? I mean, can they really just name somebody and take their property that way? And the answer, of course, is they're not taking their property. Again, they are freezing their property. But the legal basis for this is IEEPA, the International Emergency Economic Powers Act, which was passed in the 1970s. And what that does is it gives the president the power to declare a national emergency upon the finding of an extraordinary threat which has its source in whole or substantial part outside the United States to the national security, foreign policy, or economy of the United States. Once that national emergency is declared, then the executive branch, basically OFAC, has the power to sanction individuals and entities that if there is, on the basis of a finding, that sanctioning them will help protect the United States against that national security threat, against that emergency. In this case, in the case of the current Russia-Ukraine sanctions, the original executive order was issued by President Obama in March 6, 2014, after the Crimea annexation. So he found that there was a national emergency which threatened the national security of the United States based on the Crimea annexation. So that was the original executive order. That has been expanded several times. Obama issued a number of new executive orders expanding the scope of the original one. Trump issued one, President Biden has issued one. So the scope of the underlying legal basis, the executive order for the sanctions, has expanded over time. And that's what gives OFAC the authority to sanction these people. If we go to the next slide, please. There are basically 3 types of sanctions that have been used in connection with the current Russia-Ukraine situation going back to 2014. The first one is what we're really concerned about, which is blocking sanctions against the SDNs, the designated individuals, and their property. We've also got sectoral sanctions. President Obama issued some of these, or OFAC under Obama issued some of these against certain sectors, certain kinds of projects in the Russian economy. We'll probably see sectoral sanctions related to Russian oil and gas exports within the next couple of days. And then finally, we've got just the all-out investment ban and prohibition on dealings with territories that have been annexed by Russia. That began with Crimea, and of course we saw the same kind of sanctions with regard to the LNR and DNR after the annexation of those by Russia a couple of weeks ago. These are really similar to what we have with Iran and North Korea, just like all-out prohibitions on dealing with the region. So those are the 3 broad categories of sanctions that apply in the current situation. If we go to the next slide, again, what really interests us when we talk about the oligarchs are the blocking sanctions. And what the blocking sanctions mean is that once somebody is designated as an SDN, no US person can engage in any kind of transaction with the property of that SDN or property of an entity that is owned 50% or more by that SDN. This is why, I mean, I've been dealing with questions for the last, couple of weeks. Well, can we, pay interest on loans to Sberbank? A lot of Western businesses are worrying about all of these kinds of issues right now. What we can and can't do with property belonging to an SDN. Is it completely blocked? Is it only partially blocked? Do we need to get an OFAC license to engage in these transactions? These are all the kinds of issues that are worrying Western businesses that might have any kinds of dealings with SDNs or entities that they own 50% or more right now. And again, as I mentioned, the property, what this means is that the property is blocked, nobody can touch it, nobody can deal with it, but it does not get forfeited by the US government once it is once just on the basis of a blocking order. In addition, OFAC, what they often do with these, when they issue sanctions, are they simultaneously issue general licenses and specific licenses authorizing limited transactions in the block property. For example, they have authorized wind down periods for certain transactions until March 26 involving the sanctioned banks. In addition, so there's sometimes general licenses, broad wind down period for a month, wrap up your transactions with the sanctioned entity. And also there are cases in which somebody goes to OFAC for a specific license. Look, we want to conclude this transaction. The property is technically blocked. It would serve the interests of the sanctions regime to let us do this. It makes sense, et cetera, et cetera. And OFAC sometimes issues those specific licenses upon a persuasive showing. If we go to the next slide, please. There's something else that one can do when one is dealing with block property. There are opportunities for delisting. Oligarchs, sanctioned parties can go to OFAC and try to get themselves taken off of the list. And I'll talk about one example in which this was successful in a minute. And if OFAC does not agree to the delisting, it's also possible to challenge the listing through judicial process. That is extremely difficult because of the legal standards that apply to such a challenge. Our old friend, Mr. Deripaska, did both of these with regard to companies in which he had an interest. He got those delisted. He tried to challenge his personal listing through the court process. That was unsuccessful. And I think these two cases really illustrate the processes that are applied in both of these situations. And so I think they're useful to look at. If we just go to the next slide, I'll talk about each one of these. As you may remember, after the famous, the CATSA list, which was the Forbes list that the Trump administration cut and pasted from the Forbes list of oligarchs, they came out with, their own list, which was, as I say, really just the Forbes list of the most influential oligarchs in Russia. That led to certain sanctions on certain oligarchs on April 6, 2018. It also led to designations of certain of the entities that they controlled. Among those sanctioned at that time was Mr. Deripaska and certain businesses in which he had a controlling interest, including EN Plus Group, Rusal, and Eurosci Benergo, ESE. He and the management of those companies then went to OFAC and basically worked out a plan whereby he would withdraw his ownership interest of those companies. They would restructure, they would agree to certain transparency around decision-making in the companies. And basically they made this application to OFAC to get those entities delisted. OFAC agreed to do that upon a showing that this would protect market, have a beneficial effect on aluminum markets, and also Deripaska would not profit from selling his interests in these, and it would promote more transparency, open auditing, et cetera, et cetera. And so OFAC agreed to the delisting of those entities. And if you want all the details around that, a lot was published on this. OFAC under CATS was required to notify Congress of this delisting, and they sent a letter to Senator McConnell, which I've quoted here from December 2018, which really lays out all the rationale behind it. So that's sort of one process, going to OFAC for delisting. And as I say, it was successful. It took a lot of negotiation. There was a lot of back and forth, but they satisfied OFAC that this was something that made sense and would effectuate the remedial purposes of sanctions, which are to change behavior, not really to punish the entities, but to induce a change in behavior. At the same time, if we go to the next slide, Deripaska also tried to get himself delisted by OFAC, and they said, no way. We'll let your companies off because you've made a showing about how that's going to promote transparency, about how it's going to protect markets, but you, Mr. Deripaska, you're not getting off the SDN list. I said, okay, fine. I'm going to go to court and challenge this. And that's exactly what he did. He filed a claim in court that was put together by a very good lawyer. It's a well-drafted complaint from a legal perspective, basically arguing that this was a violation of his due process rights. He didn't have any notice around this. His inclusion on the list was arbitrary. They didn't really understand his business, et cetera, et cetera, et cetera. The court looked at this and said, no dice, you're not getting off the list. And the reason for that is because under US law, when there's an administrative decision based especially on a national security determination, I talked about the national emergency declared by President Obama, the deference that courts are required to be extremely deferential, and you see the language of the opinion right there, to the executive branch's decision on this. Basically, it's extremely hard to challenge this in court, because what happens, you go into court and you say, oh, they don't really know what I'm doing, it's unfair, they got me all wrong, I'm not really an oligarch, I'm just a businessman, blah, blah, blah. And what the government can do is they can make all sorts of submissions to the court relying on classified information from the intelligence community. That's not going to be shared with the applicant. And so it basically puts the applicant in a very difficult position. And that's why courts are deferential. And also, they're unlikely to say that the president, based with all the information available to the president, was wrong to declare a national security emergency. And they're also unlikely to say that OFAC was wrong based on all the information it has through the US intelligence community, say that they were wrong in identifying somebody as an appropriate candidate for sanctions. So that's the Deripaska case. Shows you it's easier to get companies off than it is individuals, and it's extremely hard to get off as an individual. Again, though, I repeat that what the sanctions mean, they do not mean seizure. They only mean blocking of the property. So they make the property useless, but they don't allow the US government to take it. So that's the sanctions regime. Now, if we go to the next slide, I want to contrast that with the forfeiture regime. And as I said before, forfeiture does result in the US government taking possession of the property. And this appears to be what President Biden was talking about last week. Forfeiture, though, is much harder than sanctioning somebody, because you have to do it pursuant. We have a rule of law in this country. We have due process. We have a takings clause. You can't just take somebody's property without judicial process. And so that's why this is much harder than sanctioning somebody. And as I said, it requires admissible evidence in court. There are basically two types of forfeiture. One is criminal forfeiture. In a criminal forfeiture case, you go out and you prosecute the individual whose property is going to be forfeited. In oligarch cases, we're usually talking about a money laundering prosecution. They've made money in some sort of corrupt means overseas. They've bought property in the US. You prosecute them for money laundering, attendant crimes, maybe it's drug trafficking, maybe it's fraud. And as a result of that, if you can show that the property that you want to forfeit was acquired with criminal means or was an instrumentality of the crime. An instrumentality could be a car that was used for a meeting to plan a crime, a house that was used for running illegal gambling operations, things like that, then you can seize it. There's another way to do forfeiture which doesn't require a criminal conviction. That's called civil forfeiture, or in rem. In rem, Latin, just means the thing in the thing. And those cases, you don't have an individual defendant. You just have the property. United States versus one penthouse at 200 Park Avenue. And the property to be seized is named as the defendant in the case, not an individual, because there is no individual. You don't have to have a criminal prosecution, but you still have to show that that property was an instrumentality or product of criminal activity by a preponderance of the evidence. So the key to both types of forfeiture is that you need evidence that the property was used to carry out criminal activity. And that's what the task force is going to be, presumably going to be focusing on. If we go to the next slide, these are just a couple great quotes from Justice Kennedy about the value of civil forfeiture. And if you look at the first one, I think this is something that's very relevant to our discussion here today. He says that, civil forfeiture is important because it allows you to seize property, not just from the person who committed the crime, but for anybody who knowingly touched that property. The third-party owner who was facilitating the laundering of the criminal proceeds, who was allowing others to carry out crimes. This owner, he says, the owner can be held accountable for the misuse of the property. And you see what the quote, the theory is that the property is hazardous in the hands of the owner because either he uses it to commit crimes or allows others to do so. And I think that's what's important here when we talk about, the so-called enablers of kleptocracy, that they are vulnerable under civil forfeiture laws, just as are the people who generated the criminal proceeds. Now, if we go to the next slide, no, this all sounds great and got a new task force and they're going to go out and they're going to seize all this dirty property. As I'm sure Karen will attest, it's not so easy in practice. It requires a lot of time, discipline, and resources. And one of the reasons we haven't seen, or this slide, I think, lists some of the challenges and explains to some extent why we haven't seen more of these cases so far. Just, at the most basic level, just locating the property can be a challenge. Now, it depends on what kind of investigation you have, how closely you've been looking at the subjects, but locating the property can be difficult. Identifying and proving who actually owns this property can be difficult. Many international criminals are quite sophisticated in how they hide their assets. A lot of these assets are hidden behind layers and layers and layers of shell companies through offshore entities, and just getting at the UBO can be very difficult, and it takes a lot of time. It takes a lot of MLAT, Mutual Legal Assistance Treaty requests, to a lot of foreign jurisdictions. You send an MLAT request to jurisdiction 1 about the ultimate beneficial owner of this company. It's registered in the Cayman Islands. They're going to say, oh, the beneficial owner is a company that's registered in the British Virgin Islands. Then you got to send another MLAT request for that. Then it comes back that that's owned by an entity in Cyprus. You got to send an MLAT request for the Cyprus entity. And so it just takes a lot of time-consuming, tedious work to get to the ultimate beneficial owner. And that's exactly why people structure these things in that way. Even more difficult, though, I think, is proving the underlying crime. If you recall what I said about how both civil and criminal forfeiture require the proof of an underlying crime and then proof of a connection between the underlying crime and the property to be seized. That is a challenge, especially with regard to Russian oligarchs. What do you do if the underlying crime that was used to purchase the penthouse on Fifth Avenue was some rigged privatization of some former Soviet factory in Irkutsk in 1993? How do you prove that that was criminal? It's not easy. You've got to get evidence of that. Getting the evidence can be a challenge. You send an MLAT request to Russia. If the oligarch is influential in Russia and has money and the ability to corrupt the judicial system, which a lot of oligarchs do, which is why we're having this discussion, they may influence the judicial system to influence prosecutors not to send back the information that you need. Even worse, they could conceivably pay to have false information created, exculpatory information. Oh yes, Mr. X, we want to comply with your request. Here's the information. The money used to purchase that factory was in fact a dividend from company Y, therefore it's all legitimate. That's a hard thing to get if you're an American prosecutor. You're looking for evidence of a crime, and what you get back from the request is evidence that this is all legitimate. That can sabotage the prosecution. So proving the underlying crime is a real challenge in these cases. Proving the connection between the crime and the property to be seized can be even more difficult. Let's say Oligarch X made their money in a rigged privatization in 1992. They then took that money and they invested into a legitimate business. That generated money, which was invested into another legitimate business and another legitimate business, another legitimate business. Legitimate business number 8 is the one that purchased the property on Fifth Avenue. How do you prove the connection between that property and the initial crime? That can be extremely difficult. When I had these cases, and again, I'm sure Karen will agree with this. I prosecuted Russian organized crime in New York when I was an assistant U.S. attorney in the Eastern District of New York. And the problem with these cases, I mean, they're incredibly important cases to make, but agents and prosecutors often have competing demands on their time. We had these kinds of cases. We also had gangs running around Brooklyn, sticking guns in people's faces, extorting businesses. Those cases demand immediate attention. Somebody could get killed if you don't take them off the street. And I think they're just, in some ways, they're more attractive from a bureaucratic perspective because you get statistics off them. You lock up 10 criminals, they get long sentences, they're doing extortions with a gunpoint. So the cases are, those cases tend to distract from the more long-term kleptocracy cases. So these cases are difficult, but they're not impossible. And the Lazarenko case involving the prosecution of the former prime minister of Ukraine for money laundering in California based on crimes committed in Ukraine proves that it can be done. It just, and I know Karen was involved in that, I hope she'll comment on that as well, proves that it can be done. It just takes a very long time and a lot of discipline. And what I'm encouraged by seeing the creation of this task force, what I've always thought in order to make these cases more doable from a DOJ perspective, was if you set up a group to do just this, and they're not distracted by the guys running around with guns, and you give them a long time horizon, it makes it much easier for prosecutors to do this case. They know they're going to be judged by different criteria. They're going to have the resources and the time that they need to put these cases together. I think that's exactly what needed to be done. So I'm encouraged that they are finally doing this. So I think it's a step in the right direction. I would just caution, we shouldn't expect results on this tomorrow. It's going to take dedicated work, a lot of going through a lot of papers to get to these, to put these cases together. But I definitely think it's a step in the right direction. If we go to the next slide, oh, sorry, go back to, you don't need to see my face on there, even look at it. Go back to the previous slide. Yeah, I think we are going to see results. We are going to see results from this. It's going to take time. And what I would say, and what I've been telling clients, is anybody in the US who touches money from that part of the world, and I think we've got to define it broadly because we all know oligarchs are not limited just to Russia. They're throughout the former Soviet Union. I think all businesses in this part of the world that have US-based businesses that have dealings with wealthy, high net worth individuals from the former Soviet Union need to be extremely careful right now. And they need to do really thorough due diligence on all of their counterparties, because law enforcement is going to be looking at them now. I'm not saying they're going to be prosecuted, but they could well get requests for interviews. They could get grand jury subpoenas. Why did you sell this property? What to so-and-so? Did you do due diligence on them? And from a business perspective, thorough due diligence is going to be the best defense. You don't know where somebody got the money to do this, but you can, and you can't be a guarantor that you're never going to be taking dirty money. You can't give an absolute guarantee of that. But what you can do is, if you do thorough due diligence, make every reasonable, good faith, and I stress good faith, effort to identify the source of the money, determine whether or not the person you're dealing with is legitimate or not. That will protect you from any law enforcement action in the long run. So basically, that's what I wanted to say. And now I hope we can open it up. Gone on probably a little bit long, but I hope we can open up to discussion. We've got a lot of great people on this who are a lot more knowledgeable about some of these issues than I am. So I hope we'll have a fulsome discussion with lots of participation.
Well, and we have a very international audience with people from Western Europe, from Ukraine. So this is great. Karen, Greenway, did you want to add anything?
Yes.
You better, Karen,
thanks,
since I advertised you so much and said you'd have so much to say. So the pressure's on. Don't disappoint.
So a couple of points is, number one, just to kind of give a better understanding here, you can go from sanctions to forfeiture. They're not two separate things. So just to be clear, we have sanctioned individuals and then forfeit their property. A good example is the Gambia, the former president of the Gambia. So he had a home in Maryland. He was sanctioned, and about a year, 18 months ago, the U.S. government filed to forfeit his interest in the home in Maryland. And then of course there is also prosecution for evasions of sanctions. The FBI and DOJ in particular have done quite a few cases where, there's been evasion of Iran sanctions, where we do prosecute individuals who evade sanctions, and we will forfeit property related to that as well. And there's been quite a bit of money. And for those of you who are paying attention, the National Crime Agency in the UK just actually got an arrest warrant for an individual in the UK who was evading sanctions in assisting Mr. Deripaska. So that is another process as well. Tom, did you want to
sorry,
jump
yeah,
back
Karen,
in on
if I could just jump. That's a great point, and I didn't mean to imply that these are two different legal processes, two different legal regimes, two different sets of governing law, but they are absolutely not mutually exclusive. Obviously, a lot of people who are sanctioned are criminals. And in fact, the fact that there is evidence of criminal activity is one of the things that is taken into account, appropriately so, by OFAC in deciding whether or not to sanction them. Also, people who are sanctioned could, that could lead to attention to their business, which could lead to a criminal prosecution or a forfeiture action. Or, as Karen rightly points out, there are prosecutions for evading sanctions. That is a separate crime, and we've seen a lot of that activity. Somebody's sanctioned, then they go through all sorts of circuitous actions. They drag in other people's front owners to hide their money. That's a separate crime, which could lead to criminal prosecution. So there's overlap between those who are sanctioned and those who are criminally prosecuted. It's, it's kind of like a Venn diagram. They kind of meet. There's an overlap in the center. Not everyone who's sanctioned is subject to criminal prosecution. Not everyone who's criminally prosecuted is sanctioned, but a lot of them are in both categories. So ideally, the two processes should work together. They're not at all mutually exclusive. I just wanted to separate them for the purpose of the discussion, because I hear so many misconceptions about, oh, somebody's sanctioned, now we're going to seize their property. So thanks for pointing that out, Karen.
There are people in this audience.
So then the last,
Yeah. Oh, sorry.
sorry, Louise.
Were you saying something?
So then the last thing I would just say is about, the forfeiture, this forfeiture, in rem forfeiture process. I've had investigations when I was in the FBI where we did actually seize property and criminal sanctions. That was ongoing businesses. And with the oligarchs, of course, you have kind of two separate buckets of what you're looking at. You're looking at what they own, through shell companies or whatever it is, their yachts, and there's been a lot of discussion in our forum about the yachts and the planes, and can you seize the plane, can you ground the planes with sanctioning, we're seizing countries in Europe who are, seizing, particularly the high dollar value yachts. And then of course there are sanctioned individuals, the Rotenbergs, for example. OCCRP did a report about a year ago that they actually have property in the United States. One of them owns a home outside of Atlanta, as does his wife, who is also sanctioned now. So you do have that bucket of real and personal, we'll call it personal property. And then of course there are potentially bank accounts. And for the understanding of the group, what happens when somebody gets sanctioned is that essentially there is a kind of a bolo of information that goes out to every financial institution in the United States, which there are more than 15,000 financial institutions. And they're basically told, go look in your system to see if you have any of these persons or companies that you are doing business with. And if you do, their accounts and any movement in and out of their accounts is immediately frozen. And a financial institution should be too, and will include, any kind of investment account as well. And what happens at that point is it just sits there. The property just sits there, the account just sits there. And then, as Tom discussed, you have this process you can go through to say, well, it's not me, or, I've changed my behavior, I'm not contributing to that anymore, so release that property back to me. Then you have the business interest. And that's where it gets very, very complicated, is what you saw with Mr. Deripaska and Rusal, because you have you might have shareholders, you might have other business interests, individuals who have an interest in the business, that 50% mark that Tom talked about. And that's and that's where what you're going to see in the, should the US government continue to expand the list of individuals that they sanction, and I'm talking about list of individuals like, not like Mr. Deripaska, Mr. Abramovich, et cetera, then it becomes more complicated, because in a lot of cases, they are the only owners of, significant assets that have business operations in the United States. And as of course, what's going to happen there is that will affect employees, the ability of the business to do business. And so when OFAC puts together a packet, those are all things that come together, in their packet as to ownership and information, and as to how this is, what will the effect be by, freezing the assets of the business assets of an individual. So part of what becomes complicated about the forfeiture process then is that, that due process of taking property rights, you have other individuals, and oftentimes what these oligarchs do is, put these assets in their families' names, their kids' names. Well, now the U.S. government isn't just faced with trying to collect evidence overseas to bring that forfeiture action. They actually have to face down the property interests that are represented by other individuals like children, et cetera. And what I was corresponding with Tom about is, for example, in the Lazarenko case, there was a criminal case where Mr. Lazarenko was prosecuted in the United States, and we seized some property and in criminal forfeiture. But then there's also, which you can do as well, a separate in rem case with other assets that he gained through this criminal activity, which was essentially bribery and extortion. And those have been in a separate criminal or separate civil in rem process for almost 15 years now. And as I was telling Tom, they were trying to, the DOJ was trying to get the property interest of his children off the property in order to be able to finally forfeit the property. And so, but they got an attorney and filed, said, no, this is legally ours. We really, we're a part of this trust, was for us, and it was legitimately gained money. They lost. Fortunately, the judge decided that their property interests were not valid, but it took 4 years to get that decision from the judge. And so these are generally long, painful cases. We've seen some big exceptions, like if you are familiar with it, the 1MBD Malaysia case. And so while we look at, or we talk about, or President Biden talks about forfeiting these properties, the reality of it is that as longer that this goes on, the more difficult it is in order to be able to forfeit it in any kind of timely manner. And of course, all of that money and all of those property interests sit there all of that time, and they don't do anybody any benefit or any good. So, so as you're looking at sanctions, absolutely, we need to stop these individuals from using and their property. But in the long term, I think you have to have a plan as to how we're going to look at really taking out and trying to at least get back some of the money that's been invested into these properties, to repatriate it to other things. Like I'm personally an advocate for putting in an account for war reparations for Ukraine. But just to give you an idea as to how these work together and the challenges of doing the forfeiture part of it, that are just beyond the usual investigation, which is these ongoing court cases over and over and over again of trying to clear out the other property interest and establish that it's from, the property was purchased with illegal proceeds, to get to the end result, to be able to forfeit the property and then repatriate it to the country where it was stolen from. So thank you.
Thank you. We have many, many questions. There are a few short ones that I want to deal with that I think are absolutely key, because we have in this audience people in DOJ and other parts of people who are working on legislation, people who are covering these issues. So Tom, Karen, how much does the absence of beneficial ownership legislation undermine the work of the task force and the ability to know who are the buyers of the property we seek to confiscate? Because at the moment, we haven't finalized yet our laws on beneficial ownership. And that seems a key way that Russians and other oligarchs are hiding their assets.
That's a great question. I think that the beneficial ownership, I mean, just by way of background, the last year we passed the Corporate Transparency Act as part of the FY21 NDAA. As I understand it, the rules, the implementing regulations around that are still being worked out, will come out in about, I think, a month or two. We're going to see those take effect. I think that was a huge step forward. I don't know if Gary Coleman or anyone who worked with him on this is on the line, but this was a really important development because without this, it was like you didn't have to. I mean, the U.S., for all of its talk at the international level about combating money laundering, was in fact a haven for money laundering because it was so easy to open anonymous shell companies in the United States. The famous study showing that it was easier to open a shell company. You had to present less information in most states of the United States to open a corporation than you did to get a library card. Really just made a vivid example of how easy it was and why it was so easy to open anonymous companies and why it was so easy to hide money through U.S. LLCs. The Corporate Transparency Act basically makes that impossible. It requires the provision of UBO information upon the registration of a corporation, identifying you have to have a warm body. You can't just, use another shell company as the UBO of the company. All of that information is going to be provided to FinCEN. That will be in a database accessible to law enforcement. So the absence of that that kind of transparency has made it easy to launder money in the United States. I think once that comes into effect, it should make it much more difficult to do so. However, we all know that it's still easy. It's still easy enough to get around these things. Karen was talking about children, relatives, you can have stand-ins. So I think that that's an important source of information, but I think it's only the beginning. It will then be incumbent upon law enforcement to take that information and take it to the next level and see, are these people who are identified in the corporate registration documents really the real owners, or are they stand-ins for somebody else? And so I think it's valuable, but it's definitely a step forward, but it's only one step in the battle. I see Karen nodding her head. I hope she'll jump in. And then I see a question from Brian Earl, who also is one of the world's great experts on this subject, was the case agent, one of the case agents on the Lazarenko case. So I hope he'll jump in as well. But Karen, I see you nodding your head on the Corporate Transparency Act.
Yeah, we are really at just the beginning here. There has been a movement by, organizations that have members who are part of our group, but we have a long way to go. And questions come up all the time of, this is what Tom talked about, this structure of one company owning another company and owning another company. And really the only way to break that chain is to determine who's the person who's actually has use and control over the property, and not really the person who is the owner on paper. But our laws require that we still have to go through the process to get all of those records in the interim. We can't just skip to the last step and say, well, they use or own it. We still have to have the record showing in court that we followed this chain of ownership to as far as we can take it.
One simple question. Do you think that the task force should be expanded to include DHS and Treasury because of the key role that FinCEN plays and the international investigative functions of DHS?
I would imagine. I don't know how go on, Karen, please.
Yeah, I thought that in the original document that created the task force, they've already been included. And that I do believe that FinCEN will play a role in this. FinCEN doesn't have the investigative role that some financial intelligence units have. They're more of a advisory role and collection role, but they will definitely be engaged in trying to help law enforcement collect the information and put it together as.
Yeah, I was just going to say the same thing. I'd be astonished if DOJ were not working closely with other agencies, including FinCEN and DHS, on gathering this information and using it. So I don't know if they're formally in the task force, but I assume they will be heavily involved in this kind of work.
All right, there are many questions here on the Magnitsky Act and how this can be used to sanction oligarchs. Is this a key tool that the government has? You didn't mention this. Does DOJ use this tool to collaborate with those involved in sanctions?
Yeah, I mean, I think that's a good point. The Magnitsky Act, there's the original Magnitsky Act from, I think, was signed into law in 2012 or 2013, and then there's the global Magnitsky Act. The original Magnitsky Act was designed to designate as SDNs those who played a role in the death of Sergei Magnitsky. A number of prosecutors, judges, prison officials were sanctioned under that. They became SDNs as a result of that. Global Magnitsky then expanded the bases for sanctioning people throughout the world, not beyond just the death of Sergei Magnitsky, to include those responsible for gross human rights violations, large-scale corruption, and a number of individuals have been sanctioned pursuant to global Magnitsky. I talked about the IEEPA designations. This is really a separate basis, but those who are sanctioned under Magnitsky or global Magnitsky become SDNs, and all of the things that I talked about applying to SDNs, blocking of property, etc., applies whether or not somebody is designated, when somebody is designated under one of those statutes as well. I mean, the president could use another authority just as they have, with the IEEPA authority. You don't necessarily need this, but that's the effect of those designations. So I think that is also a useful tool in identifying. I think it was important that global Magnitsky included corruption, not just human rights abuses. So that gives the government another basis to identify and sanction those responsible for human rights abuses and large-scale corruption.
Brian Earl, you have got your hand up.
Yeah, I'm very sorry to jump in front. There's a bunch of excellent questions here. Just a quick question for Tom and Karen. We've been here before. You mentioned Lazarenko, and remember 8 years ago there was the UFAR, the Ukrainian Forfeiture, the Ukrainian Forum on Asset Recovery after Russia took Crimea. And my question is this: well, one's rhetorical. Why did it take another land grab by Russia to bring us to this point? But really, my question is this: if sanctions have their effect, their intended effect, and the belligerence stops or reduces, or Russia somehow withdraws, what belief do you have that the current asset forfeiture efforts will have legs? As you indicated, they require a lot of resources, long-term resources. We've seen those resources dry up in the past in this very area of the world. And I hope the sanctions have the effect. I hope Russia withdraws. But if they do, I worry about the long-term efforts being long-term. It's just a question.
That's a great point. And you're right. The sanctions are really about they have a political motive. They're designed to change behavior for political reasons. Forfeiture is really just about prosecuting criminals and taking away their assets, the same as we should have been doing already. And great agents like you and Karen were doing for a long time, but it wasn't supported by the resources. I think that, if Russia withdraws, let's pray that happens, and the sanctions are lifted, who knows what'll happen, what kind of new regime there would be if they do withdraw. We don't know where it's going to go politically. But if something like that does happen and the sanctions are lifted, I would hope that the focus on the asset forfeiture would continue, because that ultimately is just ordinary criminality. And if we get the results that we want politically, the fact that people are making dirty money and laundering it through the U.S., those cases should be treated just like any other criminal case. If drug dealers were laundering money through real estate in the U.S., those cases would get appropriate attention. I think this should be the same. So I think it will be important to, if there is a resolution of the conflict, to keep the focus on the asset forfeiture. And I think that the shock of this, there were a lot of people out there talking about the problems of dirty Russian money in the US way before last week. You, Karen, Bruce Orr, a number of people were sounding the alarm bell on this for years, and it didn't really have an effect. Now it has. I hope this has been a wake-up call, and there will be sustained focus on this problem going forward, even if we do resolve the conflict in Ukraine. But Brian, you have as much insight into this as I do, having worked in the FBI on all these cases. So I'd be interested in your thoughts also.
Oh, I hope so. I hope you're right. I just wanted to put out there. Obviously, I think is obvious. So thank you both. Karen, I'm sorry.
We have some very concrete that should be answered.
I was just,
yeah.
I think it's a valid point that a year from now, 2 years from now, Are we still going to be as committed to seeing this through because these cases take so long? And I think that takes sustained support from NGOs and people like yourself who are on this, on this webinar, to keep the pressure on, because this has been going on for a really long time. This didn't happen overnight. And I think what it has exposed is the true nature of oligarch business, which was always dirty, as some of you who are on this call can attest to. And what I hope is that this time, particularly in Europe, that there is finally the will to stick with this and say, you know what, we're just not going to accept this anymore, and that they will make the commitment to put the resources to carry through on this asset forfeiture, which should have happened long ago.
I have one short question. When money is blocked, what is the status of a blocked townhouse or a tenant of a blocked office building? Is the townhouse, did they prevent it from using it by change locks? Must they preserve it in good condition if it's eventually, government must preserve it in good condition if it's eventually released?
They have to preserve it. I don't know about changing locks. They have to preserve it in good condition. If it's a bank account, they've got to put it into an interest-bearing account. And usually things like that are dealt with through the license process with OFAC. So that's, yeah, I mean, they want to preserve it in good condition because it could eventually be disposed of, returned, et cetera, et cetera. Just going back, I know we want to move on, but just going back to the previous point about, what's going to happen if this is resolved. Are we going to have sustained focus on the forfeiture? I am hoping that what will happen is that this will become a machine that runs of its own power on the private sector side, because I think as a result of this, businesses are going to be doing a lot more thorough due diligence on their counterparties. And if that becomes institutionalized, like it did with, banks with the AML regime a long time ago, like it has with FCPA, a lot of this will hopefully be cut off at the first step by businesses saying, we're not going to deal with it. They're going to do their own investigation. This is dirty money. We're not going to deal with this. And hopefully that will help to address a lot of the problem.
Next question. What are the main differences between the US government approach process and those of the UK, EU, Canada, Australia, New Zealand? And also should say about Switzerland, there was a question on some that Putin's mistress and her family have property in Switzerland. What can we expect?
Yeah, well, I'm not licensed to practice in any of those jurisdictions, so I have to be careful what I say. I think that the essentials of the regimes are the same. I think there are differences in the nuances in each country. As I understand, I don't think the UK has a delisting process. The EU has not just 50% rule, they have ownership or control. So even if it's below 50%, if you have de facto control, then that's considered block property. Each one of these, though, and I have to give a brief advertisement for my profession and local lawyers. When you deal with sanctions issues in each country, it is extremely important to get qualified local counsel because there are important nuanced differences. As for Switzerland, I don't know, but I would imagine, again, it's not, for them to seize property belonging to Putin's mistress or children or whatever, they would have to go through, I presumably have to go through some judicial process just as we would. And one point I just want to make, I know there's been a lot of discussion on this forum about identifying the assets, which is extremely important. As I said, that's really step one. You can't seize something unless you know that it exists in the first place. But identification of the assets, there's a long road from identification of the assets to actual seizure of the assets. And so when we see frustration, oh, somebody's got a palace here, a jet there, it's not so easy. Identification is necessary, but not sufficient to actually seize the asset.
There are many people on this call in civil society who are involved in locating assets. And one of the things that I think is important, I don't know if there's anyone from the task force here, but that there be some kind of advisory mechanism of this incredibly sophisticated community that's online here to help make the work of the task force easier. And I know Tom and I discussed this, and maybe you have a few things to say on that.
Yeah, I think that would be a great idea. And again, I'd be interested in what Brian and Karen think about this. When I was a prosecutor, we typically got information through traditional law enforcement techniques: surveillance, wiretaps, grand jury subpoenas, informants, information from participants. We didn't get a lot from civil society or from purely private parties. I think that that's changing. And I think when we talk about the difficulties of collecting evidence overseas, it is important to rely on civil society. There are great activists in Russia, in Ukraine, who have identified these assets, who may have information that U.S. law enforcement is not immediately privy to. So I think that some cooperation with them is extremely important. And I think that any information received from them will have to be vetted to make sure that it's admissible in court, that it's reliable. But I do think that that is a very valuable source of information that law enforcement has been making more use of and should continue to do so. And I know, Karen, when the last several years you were at the FBI, you were doing a lot more private sector outreach than would have been done 15 or 20 years ago. And maybe, I know you've worked with a lot of activist organizations in Ukraine. Maybe you could add a couple words on that also.
Yeah, so just really briefly on the sanctions discussion about other countries is, one of the challenges is that, a couple of these are very new. Australia is a perfect example. Theirs were just brought into the law last fall as it relates particularly to corruption. So we don't have, they haven't really been judicially tested. And one question in the chat is about unexplained wealth orders. Do we think the U.S. will expand to potentially using those? My answer is most likely never, just because of the way that our law is concerning property rights. But they also have challenges in that not many of them have made it very far beyond the first level. So some of this is just going to be seeing how this goes through the judiciary in the next couple of years, because we haven't had a lot of testing. And then the thing that I would add about the information to the task force is absolutely, one of the things that Global Magnitsky does is it gives civil society a voice in bringing forward packets of information to OFAC to seek sanctions on different individuals. And I have worked with civil society to do exactly that, but I've also worked with civil society to bring packets forward to Department of Justice on potential assets that could be frozen. And so we work on putting those packets together to get law enforcement as much as possible as what I like to define it as actionable intelligence, so that they're not starting from zero and going to look for whatever is out there. On the reverse, I also tell people that we don't want to just hand over a database to law enforcement and say, find the crime. And the reason is because, law enforcement, generally doesn't have the legal mandate to go looking in a database that we hand them, and we don't really want law enforcement to spend their time doing that, but what I would also caution people is, as we are putting packets together, I made the point that, we have to not rely on, unfortunately, on some of the leaks, because those leaks were from privileged databases. So we do have to be careful as to what we do give law enforcement, because otherwise what we end up doing is literally you can taint out an investigator because they've seen something that was privileged. And now the courts would take that very seriously and say that they would no longer be allowed to be involved in that aspect of the case because they've seen something that's privileged. So, I would just put those two words of caution in there in putting this all together.
Another word of caution, that's a great point. The precedent already exists from Global Magnitsky. We've had that transmission of information from civil society. That is great. And Louise, I think the idea about the advisory committee is a great one to filter all that information. The other cautionary word I would add is that I would not put it beyond the oligarchs to set up phony NGOs to try to use this in order, oligarch A is in a dispute with oligarch B. Oligarch A sets up some phony NGO which provides information against oligarch B, and we wouldn't want the process to be perverted that way. So all the more important, it's important to receive the information, but to vet it. And, as somebody once said, trust but verify. And I think that is a good mantra for this situation.
Next question. We got so many more. This is from Jody. There have been lots of talk about oligarchs giving money to charities and foundations. including Abramovich's original attempt to move Chelsea to his foundation? Will charities and foundations associated with oligarchs also be sanctioned? And can charities use these assets?
Well, I think the question is it a bona fide charity or is it a phony charity set up for the purposes of money laundering? If it's the latter, then I think it'd be an appropriate candidate for sanctions. If it's a bona fide charity, then they have to make the decision. Do we want to take money from this oligarch? They couldn't take them if it's sanctioned, but do we want to take this money from this oligarch for reputational reasons? We see this situation a lot in the FCPA world. Donations, companies make donations to charities overseas, and the question is always the same. Is it a legitimate bona fide charity? Is the payment being made pursuant to the company's ordinary CSR programs? Or is it the alter ego of the, brother of the mayor, and you need to make this donation in order to get a contract? I think the same sorts of considerations would apply here. You want to look at, is it a real charity that is doing real work, and is the oligarch making the donation in good faith? And then then it's really a question for the charity, how closely associated do they want to be with the oligarch? And I think there are two schools of thought on this. If they have the money and they're giving it to a good cause, great, we want to use that money for good causes. I think the other school of thought, obviously, is this money is tainted. We don't want to have anything to do with it, and it will taint us if we take the money, even if we're using it for good purposes. So that's a question to make, to pose to every, that every charity has to consider on its own. Whether or not they'll be sanctioned, I think it comes down to whether or not they are, as I say, real charities will not be sanctioned. Charities that are being used as for corrupt laundering purposes would certainly be appropriate candidates for that.
We've had that issue in the U.S. with the Sacklers and reputation laundering through charities, which we've dealt with a lot in the United States.
Absolutely.
So it's not just a foreign problem.
Absolutely.
Next question. Will you explain the use of the art market by oligarchs to launder or create a legal front for assets? How will sanctions, freezing, and seizing of assets be handled? And beyond that, on art market, I wanted to ask also about hedge funds and venture capital money.
That's a great question. The art market is a fascinating subject. I would refer everyone who's interested in this, first of all, to read the report of the Senate Permanent Subcommittee on Investigations about laundering and sanctions evasion through the art market. I think it came out in July of 2020. It focused on the Rotenberg brothers, and it made the point that the art market is ripe for this and very vulnerable to this. Pursuant to the FY21 NDAA, Treasury was required to produce a report about the risks of money laundering in the art market, which they came out with in February. That report was a little bit more sanguine about this, saying, well, the art market can be used for laundering, but it's really only the high end part of the art market, which is only a small part of it. And they were focused much more on NFTs and how NFTs are on track and ripe for money laundering. I think when we talk about the art market, there are sort of two schools of thought, depending on who you talk to. One is that, the art market is, very susceptible to money laundering because it's anonymous, so you don't have to identify yourself. Two, the prices of these things are very subjective. So if I want to spend, $20 million on a Picasso, who's to say it's not worth $20 million? If you try to do the same thing with a piece of real estate, it's much more of a red flag, but the value is subjective. You don't have to identify. There's been secrecy in the art market for years for valid reasons, and so that lends itself to money laundering. The flip side is that, the point of money laundering is put dirty money into a clean asset, then liquidate the clean asset, and then show the money that comes out the other side as being clean. That's hard to do with art because you'd have to have a ready buyer for the $20 million Picasso in order to make the scheme work. So I think it's definitely, there are definitely vulnerabilities there, and I think the art market needs to look very closely at this. The art industry needs to look closely at this. I don't think it, but there are also issues that make it hard. As for venture capital and hedge funds, I think that those are obviously not public. They not subject to SEC regulations, so I think it does make it easier to move dirty money through those. I think private equity is harder just because the nature of the investments tend to be long-term and illiquid, but it doesn't mean it can't be done. I think with all of these, though, the best formula from a law enforcement perspective is to put the onus on the businesses themselves to do due diligence, because law enforcement can't uncover every case of money laundering through this. They don't have access to all of this information. information, the direct counterparty has access to the information. And if you put the onus on them to identify who they're doing business with, and you create incentives for them to comply and strong disincentives for them to violate the law with some, high profile cases, you will get them enforcing all of this. So I think that the strategy for law enforcement has to come up with a way to put the onus on these intermediaries without killing their businesses. So reasonable burdens that can be met without killing the business and will be helpful in identifying and cutting off these illegal transactions. But Louise, you've written much more on the venture capital and hedge funds, and you've looked at this more deeply, so you probably have more thoughts on this than I do. I think any sort of investment can be used for money laundering if it's structured the right way. Those which are less transparent are more vulnerable to that, and those as opposed to publicly traded companies are obviously less transparent than an SEC registered company, so they do lend themselves to it. But the key, I think, is really to get the gatekeepers to do due diligence. But I'm sure you have thoughts on this as well.
I think that as we see certain areas being cleaned up in the financial markets and investment markets, you're going to be looking and seeing new frontiers where there's already been movement of illicit funds, and we need to be very flexible in the way we approach this subject and not fight last year's wars, but also look at where we need to be going next. Because as all of you have talked about, there are very clever enablers working with all of these oligarchs and advising them. And maybe we could say a little bit more about the need to address enablers.
Well, yeah, I just want to say as a lawyer, not everyone in the asset management business, law, accounting, real estate brokering, I think that the ethical people in those professions are the best line of defense against this sort of thing. I mean, every law firm I've ever worked with had very thorough due diligence vetting, client intake to make sure we're not doing anything that could be interpreted as enabling. And I think that that is really important. The corrupt actors, and they are a minority in every one of those professions, are the ones that need to be targeted, because it's difficult, as Karen and I were talking about, it's difficult to prove the ultimate crime overseas. But if you have somebody who takes money, they should know it's dirty money. There are all sorts of red flags around the deposit or the purchase or whatever, and they turn a blind eye to that. They should, of course, be subject to some sort of action. And when you do that, that I think induces compliance and KYC, robust KYC, on the part of everyone else in the profession. So I think that targeting these professions, not necessarily for prosecution, because I say a lot of them are, the majority of people in every one of these professions is honest, but making clear to them that the expectation is that they will do thorough KYC, making clear to them that the standard, I mean, we have this in the FCPA all the time, the standard is knew or should have known. If you turn a blind eye to red flags, that is the same as knowingly taking dirty money. And I think that that message needs to be conveyed. And I think that lawyers, good lawyers such as myself, consultants like Karen, we can work with companies to help them identify those red flags so they don't take these clients, and that they're protected in case anything goes wrong. So I think that that really needs to be the focus, inducing robust KYC and compliance on the part of the intermediaries. And that's really the best defense.
Okay.
I would just also add, sorry, Louise, I would also add really quickly that we have prosecuted lawyers. We have prosecuted, back in the days when Tom and I were back working organized crime, we were prosecuting stockbrokers who were involved with organized crime groups, to facilitate both money laundering as well as a variety of scams. So we do and have prosecuted them. I think the biggest challenge for lawyers relates to attorney-client privilege. And my argument always has been, and will continue to be, is why should a lawyer be able to argue attorney-client privilege for the creation of a company if in Arkansas, you have to go through a lawyer to create a company, and that's privileged, when it's not privileged, to create a company in Delaware if it's created by an incorporator. And particularly since we see with ultimate beneficial ownership issues, where a lawyer or an incorporator in the U.S. just gets a request from another incorporator outside the country, and they have no idea who's the person who's really behind it, and they don't engage in any kind of checking. What kind of privilege is there with that request if it's just from another incorporator outside the country, regardless of whether a lawyer or not? I think that's the one key fact about ultimate beneficial ownership when you're looking at enablers. That really is the biggest challenge, is this issue of, that in some cases it's considered a privileged relationship and in other cases it's not. And that should be something that's uniform, particularly if there's no real client at the other end of that request to create a corporation, particularly in the United States.
And the privilege does not, there's a crime fraud exception to the privilege. So if you are knowingly helping somebody launder money as a lawyer, that's not privilege, that's criminal activity, and that's not protected by the privilege.
Thank you. Next question. Nikolai Petrovich Tokarev was sanctioned by the U.S. Treasury, including his family's property in Croatia. What entities are monitoring the enforcement of sanctions in the case of Croatia, and what is the procedure to add new individuals to be sanctioned?
I would imagine that this is the same entities that monitor sanctions across the board, DOJ and OFAC. The process for adding people is exactly what I said. This is, it's done by Treasury with input from a variety of sources, including, so we've been talking about civil society. So I would, encourage people who have information about people they think should be sanctioned. You can provide that to OFAC and DOJ. The Tokarev case, I don't know anything specific about it, so I can't really comment beyond that.
Anything, Karen or Brian? All right, on to the next question. Do these sanctions apply to cryptocurrency and assets stored in blockchain as well?
Well, the sanctions apply to any property. So if cryptocurrency is a property, which it is, it would apply to those as well. So yes, there's no, as far as I know, there is no special rule carve out or anything for cryptocurrency. It's treated just like other forms of assets. I think that's a subject for another day. There's been a lot of discussion about potential for money laundering through cryptocurrency. And again, there's different schools of thought on that. Does it facilitate it? Is it harder through cryptocurrency? But I think that's a subject for real study and analysis, given that it's an emerging form of currency.
Paul Radu, who's one of the founders of OCCRP, which was mentioned earlier, said that they've come across real estate sold via NFTs. So there are all kinds of frontiers that we need to be looking at. And thank goodness there are many investigative journalists in this community who are looking at them. Let's go on to. So there's a lot of questions on intermediaries. Let's see.
So while you're looking for that, Luis, one of the things that I would just say is going back to that discussion about art is, one of the things that we have seen is that, it isn't just the purchase of art. Art is usually purchased through a facilitator, or an auction house. And one of the things that we have seen is that auction houses have been willing to make some unusual deals related to art. For example, we saw in the 1MBD Malaysia case where the auction house, who had actually sold some art to one of the main subjects, Jolo, was actually willing to take the art back and give Jolo credit, financial, in other words, a loan essentially based on the art until they could resell it. And so that did take some of the art out of the reach of the U.S. government, to be able to forfeit it. And that is a place where I think that we can be watching is the facilitators of the sale of and resale of art, who in some cases are not subject to anything more than CTR requirements, cash transaction report requirements, depending on the country they're in. And then, of course, the other thing is that has been mentioned too, as it relates to airplanes, and jets. And some of you have written some pieces on this, but in the United States, when we passed essentially our greatly revised rules on anti-money laundering and terrorism financing that came out after 9/11, one of the exemptions, to the compliance of the new enhanced anti-money laundering reporting rules was aircraft title companies. So in other words, there are only a couple of them in the United States, but if you buy your jet or airplane or helicopter, and we found this with Ukraine through one, and use one of these title companies to settle the sale, just like you would use for your house, they don't have any reporting requirements. So we have seen, where money comes in to pay for that helicopter or that jet, and it's more than is necessary to pay for it, and then the money goes off to a third, a suspicious third shell company. So that is one of the challenges that has been brought up about, the aircraft issue, is, first of all, finding the ownership, and then finding the records as how it was paid for, and then seeing these shell companies, contributing the money to pay for them and then being able to trace them. Again, it goes back to the use, what I talked about earlier. Who is the one who is on that plane and or aircraft or jet or whatever it might be. But it is just something to be aware of as we're looking at, potentially giving to the U.S. government when you're looking at these jets, and airplanes, that there's going to be potential issues where they're not necessarily reporting requirements that have to be complied with, and the sales look, perfectly legal, under current U.S. anti-money laundering.
Okay, we have one question. I have one question that takes us back to Tom's early expertise, which is on corporate raiding. And I want you to explain corporate raiding and how oligarchs have helped destroy entrepreneurship in Russia by taking over assets of other business people, using often the criminal law, and how in 2020 there were 200,000 Russian businessmen who were incarcerated. This is an official Russian statistic, while others were taking over their businesses. And so many of these wealthy business people send money overseas because they can lose everything within Russia. So how do we address this issue of differentiating between oligarchical money and victims of corporate raiding who are sending money overseas? And how do we inform this discussion as we go forth in targeting Russian assets?
That is a great question. And to go back to how do we distinguish between an oligarch and a victim of raiding or a legitimate businessman is a great question. Oligarch, there's no legal definition of it. It's just a term that's used to describe rich Russians and some rich people from other countries of the world. It doesn't. There are legitimate business people in Russia who made a lot of money legitimately, and there are not. I think when we talk about, so I think that's something that needs to be discussed when we talk about oligarchs. Who exactly are we talking about? And I think we need some clear-cut definition. I think what we're talking about in the current discussion, coming off the president's speech, is wealthy Russians who are in Putin's inner circle, who influence politics and have used their access to political power to gain money illegally. I think that's what we're really talking about. We're not talking about the legitimate people or wealthy people. We're talking about those who have exploited state resources to get rich in an illegitimate way. A corporate raiding is a perfect example of this, and thanks for bringing that up. When I went to work at the U.S. Embassy in 2006, I had been prosecuting organized crime in the Eastern District of New York, and I was very interested in organized crime in Russia. And I still thought of it, the way we discussed it 20 years ago, Taiwanchik, Yaponchik, the old sort of school Russian organized crime, the guys who had been in prison in the Soviet Union, tattoos, gold teeth, petty extortion, et cetera, et cetera. But what I saw when I got there in the mid-2000s was that it had really transformed, and the most pernicious form of organized crime in Russia at that time was corporate raiding, which I distinguish from traditional organized crime or Wall Street financial raiding, in that really what it is, it's the criminal misappropriation of assets through abuse of the legal system. So what you have in corporate raiding is it's not just, mafia guys go into a store and say half of your profits are now ours, and if you don't comply, we're going to burn your store down. What it is they enter into some sort of contractual agreement with the target business or some sort of business relationship. Then typically what they do is they claim a debt, that the business owes them a debt. They corrupt the judicial system. They get an order authorizing them to seize the business's assets in satisfaction of that debt. And then they send in their security forces or judicial bailiffs who are also on the payroll to take the asset from the target. This, I think, is a much more pernicious form of organized crime than traditional organized crime because it masquerades, it operates under the guise of enforcing legal orders. It is papered over with these legal documents, proving that this is gangsterism rather than just doing God's work of enforcing a legitimate judicial order is extremely difficult. And that's why it's so sophisticated. This proliferated in modern Russia, and to the point where even President Putin, even then President Medvedev came out against it. They appointed a special ombudsman for protection of business rights, business people's rights, because this was so prevalent. They put in a special law making it illegal to detain somebody pre-trial if they were charged with an entrepreneurial crime, because there was so much abuse of the process, locking up business people pre-trial as a way to extort on fabricated criminal charges as a way to extort them. So this is a massive problem in Russia. As you point out, what makes it difficult for our subject is some of the people who have been victimized by raiding may be oligarchs as well. Somebody can be both a criminal and a victim at the same time. And those of us who worked in organized crime cases saw this situation all the time. The victim of the mafia is often somebody who's running an illegal gambling operation or illegal prostitution. So we have that situation. I think that the bona fide victims of raiding, though, the people who are sitting in jail on these fabricated charges, should not be considered oligarchs for these purposes, just because what I think the president is really trying to get at and what the task force is really trying to get at is those who have influence over the political system in Russia, who are, close to Putin, the cronies. That's what we're really trying to get at. If somebody's in jail because somebody else used political resources against them, it's unlikely that they have that degree of political influence. So I don't think those are the oligarchs we're talking about now. But going back to Brian's point, they could still be worthy of criminal prosecution in the U.S. for other crimes that they've committed. So I think this is just a long way of saying, and it's a very lawyerly answer, every case has to be looked at on its own facts. There are oligarchs who are criminals, oligarchs who are not criminals, criminals who are oligarchs, criminals who are not oligarchs. We need to look at every case on its own facts. But I think what we're talking about now, given the current political situation, is going after the assets of those oligarchs who have profited from and propped up the Putin regime.
But what we've seen, and I think it's very important, is that some of the, like Sberbank, when it was put under sanctions before, then starts targeting other less protected oligarchs. So if we're trying to look at and use these sanctions as a way of weakening the government and the people around Putin, we need to think very carefully about where there's anger, resentment against the government and who we're targeting. And I think that's a very subtle issue that that one needs to look at.
I think that's absolutely right. I just see a question. Somebody said, "Do you honestly believe they're oligarchs who are not criminals? Give us a name." What I meant is we don't have a definition of oligarch. What I meant is really there are wealthy people in Russia who are not criminals. Not every person who made money in Russia is a criminal or worthy of sanctions. But I think your point, Louise, is a very good one. That goes back to what I said at the beginning, that there's a difference. Sanctions are about political motivations, a political tool. Forfeiture is a law enforcement tool. And so I think that's why you're absolutely right. When we look at who we want to sanction, it's got to be done with the political eye. What is the effect of this going to be? Criminal forfeiture, I think we should, civil forfeiture, if somebody's committed a crime, they should be subject to criminal process just like anybody else, regardless of the politics around it. Thank you.
Can we share your slides, Tom?
Sure, absolutely.
And there's a last question from Marshall Jones. Is there evidence linking Russian oligarchs with Ivory, rhino horns, and illegal wildlife trafficking? Does the Lacy Act provide authority for seizures and prosecutions?
I think the answer, it's been a while since I looked at the Lacy Act. I think the answer to that is yes. And when I was a prosecutor, I definitely had cases involving Russian organized crime figures with illegal wildlife trafficking. I saw a lot in illegal caviar trafficking, among other things. We know there's illegal timber trafficking from the Russian Far East. And again, Louise, you guys have done more research on this than anybody, so I would defer to you. But I definitely think that is one of the tools in the law enforcement arsenal that should be looked at, because that, just like any other form of illegal trafficking, is a big business for organized crime.
Sally Stoker, who's online, worked long and hard on this issue. I should also point out that we also have oligarchs who are involved in overseas activities in Central America, causing great environmental destruction, and also being involved in corruption and stirring up political discontent. And that's another thing that we should also be looking at. I know there's some journalists working on those issues.
Yeah, what this all comes back to is the fusion of dirty money and political influence. That permeates everything we're talking about today. And I think that has to be a focus for the political sector and the law enforcement sector going forward. I think that we had traditionally thought about, there's the criminal world over here, there's the political world over here. What we've seen is a convergence of those two. And I think that's why, going back to your point, Louise, Treasury has to be part of the task force. These two, OFAC, DOJ need to work together, and all of us need to work together to look at these issues in a comprehensive way.
So our time is
I
up.
would just add,
Oh, sorry, Karen, go ahead.
sorry, I'll give you one final word, that there is a third rail in here, and that's the Russian intelligence services. And that's what really connects these two to make it political, is that what we're talking about here is oligarchs, not just to have these foreign businesses and in other countries, is that in their businesses and with their businesses, that they have been facilitators for Russian intelligence activities in all of our countries. And as a result, taking, Putin's history, with the services, he really has been, the person who brought all together the intelligence services, organized crime, and these corrupt, businessmen who became oligarchs into this triangle of support for, putting out, Putin's ideology as to what Russia was and what Russia's influence was in all of our countries. And that's what we're seeing as well, is that those people who are around Putin are the people who have allowed and facilitated Russian intelligence operations. And that's really the danger that they have brought into our countries, not just the dirty money, but using their businesses as a way to bring, intelligence operations into our countries, to support intelligence operations, and to facilitate into all our countries the movements of money that have been used to, put out propaganda, to destabilize relationships, in everything that we have seen, and that we are calling, that we have now identified as deep fake. I mean, that's the third rail here, and that's what we're trying to get at, is those people who have been the facilitators of these, movements of money and movements of influence, that have destabilized, our countries through misinformation and propaganda.
Thank you so much. That was just really helpful. And I think it's absolutely critical importance that we look at this role of the security apparatus and the KGB and FSB community. Quoting the president of Moldova, who is such a reformist against that corrupt government, and she said recently, the corruption from here has corrupted your governments as well. And I think that's a key point, that this is a critical moment for us to think about how our society has been corrupted and what we need to do to clean it up, because we're also been part of the problem. And that's the work that all of us as this ACAN community do together, and many of the others of you who are on this call. So thank you. And thank you for this wonderful presentation. Tom, thank you for adding so much to this, Karen, and for this being such an incredibly dynamic community. And ACAN is ready to put on some more events as needed. We're in a critical time and we need really sophisticated, high-level discussions. And I'm sure that many of you are going to stay deeply involved in these issues. So thank you all. Bye-bye.
Thank you.
And thank you to our global audience.
Thank you.